Good morning. I'm United States Attorney Zachary Cunha. Thank you for joining us today. In May of this year, we announced this office's findings in a civil rights investigation into the state of Rhode Island developmental disabilities. That failure concerned a repeated, persistent pattern of behavior in which these children were unnecessarily and illegally confined in an acute care psychiatric institution intended for short-term admissions, often for weeks or months longer than their conditions required, and when they could have been and should have been released to receive care in the most integrated setting possible, whether that's in their own home, a foster home, or in their community. I described those findings in May not just as illegal, but as heartbreaking, because they are. Today, roughly 6 months later, I am pleased to announce that we have reached an agreement with the state of Rhode Island to resolve the government's findings. That agreement takes the form of a consent decree that has this morning been filed in federal district court here in Providence alongside a civil complaint. You should all have copies of those documents by now. And if approved by the court, for the next 5 years, this decree will impose long-term, measurable, and by far most importantly, enforceable requirements as to how the state treats these children. In just a moment, I will walk you through the provisions of this agreement, but before I do that, I want to introduce Assistant U.S. Attorney Amy Romero, who has led this investigation and whose tenacity and extraordinary work have brought us to where we are today. I am also joined by Associate Deputy Director of Strategic Planning, Susan Rhodes, and Investigator Erin Walker of the Department of Health and Human Services Office of Civil Rights, which has been a full and indispensable partner in this investigation. Shortly, you will hear from Associate Deputy Director Rhodes, but I want to express my deep appreciation to her, to OCR Director Melanie Fontes-Renier, and frankly to your entire agency for the work we have done together on this case and the progress that we announced today. Now to the decree. The first and most important thing that I want to emphasize is that a consent decree is enforceable. If approved by the court, compliance will be overseen from multiple angles. A court-appointed monitor will be named and will be actively involved in the decree's implementation with the ability and the obligation to report to the federal court about compliance and progress. Second, this office will retain the ability to bring issues requiring attention or correction to the court. And critically, a consent decree is a court order overseen by a United States District Judge who will have the ability to enforce compliance with its terms and who, not the parties, will ultimately determine if the decree's terms are satisfied. So what are those terms? The consent decree, first and foremost, defines and covers what is called a focus population. That means children with an open case with the Department of Children, Youth, and Families. That includes children who are in state custody, and it also includes children who are being served through the voluntary Children's Behavioral Health Unit. It covers any of those children who are currently admitted to Bradley Hospital, who were previously hospitalized at Bradley within the past year, who become admitted to Bradley during the life of the consent decree, and finally, regardless of whether they have or have had any contact with Bradley Hospital, it covers kids under DCYF supervision who have 3 or more emergency room visits for behavioral health issues within a 12-month period. That last group is known as the at-risk population. And let me just briefly say this, as I did in May. This case is not about Bradley Hospital's conduct. We have not, and we do not allege that the hospital has engaged in any wrongdoing, nor do we take any issue with their medical care. They have been eminently cooperative during our investigation, but this case is not about and has never been about Bradley. It's about the state and the state's obligations to these kids. Now, returning to the terms of the consent decree, every child in the focus population will have a child and family team. This team will include the child, their family, their DCYF caseworker, advocates, and any natural supports. That could be extended family members or friends. This team will develop an individualized service plan, or an ISP, based on a clinical assessment that addresses the goals and needs of each child and their families. This ISP is important for identifying gaps in services that child or their family may need. Each child will also have care coordination, which will be proactive to ensure the children receive the services that have been identified under their ISP. Transition coordinators will be assigned to every child in the focus population who is hospitalized, and those transition coordinators will develop a written transition plan that identifies the services necessary for that child to succeed in a home or community setting. Doctors will still decide if and when a child is stable enough to leave a hospital setting, but once the doctor deems the child ready to leave the hospital, the transition coordinator, along with the child and family team, will ensure that the child is discharged to the most integrated setting appropriate to their needs. The state will ensure that children in the focus population have access to the community-based services they need in order to help those children and their families build the skills necessary in a home, in their own home. Their services include in-home individual therapy, in-home family therapy, and mentoring. And in order to ensure that those services are available, the state is going to come up with a workforce development plan to address workforce shortages in children's providers. The state will recruit and retain more therapeutic foster care parents and will offer mobile crisis assistance in order to stabilize emergencies and keep children out of hospitals in the first place. And finally, the state has committed to providing quarterly data reports, which will be publicly available on its website. Those are the terms. Now what comes next? The state has agreed to hire a third-party consultant who will assess existing systems, capacities, and limitations, who will speak to stakeholders and will provide recommendations. Based on those recommendations, the state will submit a proposed implementation plan detailing how it's going to do all of the above. And that will be subject to approval by the monitor and by the United States. Because stakeholder input is key, the state will also create an advisory group to solicit that input. There are timelines built into the consent decree for compliance with all of these different provisions that I have mentioned, and as I say, the entire consent decree will be monitored by a court-appointed monitor and ultimately by a federal judge. It will last 5 years, as long as the state has met and sustained compliance with all of its provisions for at least a one-year period. Early termination of the decree is possible, and frankly, given what that would imply, would be welcome, but that will only happen if compliance by the state is not only achieved, but sustained. Now, before I turn this over to the Associate Deputy Director, let me offer one final observation. This is not a declaration of victory. Success is not smiling. Success is getting kids who don't need to be there out of a locked ward and back into safe homes and communities with the chance to laugh and play and learn and have a childhood. But today is an important step towards that goal. It reflects a commitment by the state towards reaching that goal, and I want to commend the state and DCYF for their willingness to engage with us and the commitment on their part to moving forward in good faith to comply with the law and do right by these kids. The eyes of this office, the eyes of a federal judge, and equally importantly, I hope and believe the eyes of the public will remain on this issue to ensure that no child in our state is deprived of their civil rights in this way.